payments for the coal used to be made issued for recording his statement. Coal from so and so constitutes of that residents of so and so and committed an act which constitute money laundering. Further investigation regarding the utilization of crime generated from coal sales. National Hawala. One such Hawala has been identified from WhatsApp Hawala transfers by the coal source of proceeds of crime from who handled the Hawala transfer. Third, we disclosed that 20 crore Hawala networks layered through a into. Now please see IP. It means the meaning changes. IPACs and for search under section shooting its work. Thus the search in Kolkata on 8th
same ED-I-Pac with which earlier
premises, one of the premises was the residence Calcutta, Sri so and so number so and so to carry out the search premises of Mr. Pratik Jain under SS Indian Pac Consulting Private Limited has arrived at their respective premises if they wanted to continue their
officers were possessed of.
Yes, madam. Also that this is the authority under which we political activities, if any. What was there to hide that such a along with the Director General then my lord, for search at a residential premises of Mr. 26, various digital to the PMLA investigation. So and so Deputy Commissioner of Police complaint of house trespass has been proceedings. The DCP was shown the thereafter Sri Manoj Kumar Verma officers were being briefed about the search. Miss so and so sitting on the premises despite making categorical PMLA, however violating all of all digital devices. Sri so and so assistant director, 15 p.m. All the proceedings have incident report dated so and so was also. We see the totality of this. Later, the people who come, these are our identity cards. This is our. My lord, this to take the increase. First time this has happened. Decided. Has not filed any complaint. Or even invaded, etc. He could not have. But everyone, my lord, is. And my learned senior.
We have filed.
Yes.
Is this incident or some other incident?
Colored photographs, my lord. You are not this. Colored photographs.
Some color, some black.
This incident.
81.
In a light.
Think in lighter way.
I need to respond to all what you have said.
We listen notice.
I'm sorry?
And we want to examine.
That.
Yes, please.
Yes, I just want. Who is ED-I-Pac? And I'm sure they know. Number two,
And I'm
who
for
is
one
the
and three.
chairman?
Happens to be the chief minister also.
Happens to.
Only a minute. When you say chairman,
argue before.
Let it not decide who.
no, certainly.
Allow us to argue. We'll come to the issue. The High Court cannot hear this petition. And hear this petition, then why should your lordship?
Most
That's not going to be repeated, Mother. So your lordships will have to now assume to say that, Mullahs.
You cannot put what
Of course,
accessible.
of course, but my argument at the initial stage is because the High Court is the court on the basis of whatever they are come to this court. That's the hierarchy to the High Court. And their argument is proceedings could not take place. Yesterday, hearing took place, and the hearing. That's point number one.
Yesterday, Mr. Mehta's. Can I finish, please, sir? So the High Supreme Court is over, etc. So yes, in the statement, which is why the yesterday order was.
Nominals on the ED-I-Pac, we all know, Mullahs. Bengal. If way back in
No, elections in West Bengal are
of this agreement, confidential or non-public information of any of information of facts, all the ED knows about it. A lot of information in respect of the go what we're going to do. I'm sure they knew about it. Midst of an election. Now, but in the coal scam, was 2024. In 2024, so keen in the midst of an election, and he's saying we want for what? Get possession of that information. How are we going to find? Chairman has a right to go. It's the property. Pack the at 6:20 in the he went at 6:20. Went away at about 12:15.
They collected everything in it.
There is a provision in the BNSS which says that 105, and the lies will be demonstrated if they show the video. Take 105 of BNSS. We're also very disturbed, Mullahs. Extremely disturbed as to what is happening. Why should ED Mullahs wait for 2 years to come to West Bengal and go to an office which is a party office, which has all the data with all the information? It's part of party office. Kindly see 105. the process of conducting search of a place or taking possession of any property, article or thing under this chapter, or under 185, including preparation of the list of all things seized in the course of such search and seizure, and signing of such list by witnesses, shall be recorded through an audio-video electronic means, preferably mobile phone, and the police officer shall without delay forward such recording to the district magistrate, subdivisional magistrate, or judicial magistrate. Please show that recording. Everything that is in the statement will be proved to be a lie. That respondent number 2 took all the devices. It's an absolute lie. And it's contradicted by their own Panchnama in this petition. I read the Panchmana to you. This is very unfortunate, Mullahs. And that's why, in a matter of this nature, Mullahs, and I'll come to the law a little later, Mullahs, this is just to create prejudice. Now kindly come to the Panchnama. 66, Mullahs. I'm going to show you. Page 66. Mullahs, kindly come to 66. We above named Panchas, your lordship sees that? And kindly come, they show that, search was conducted. Now kindly come to 68. Yes, kindly see. During the course of the search, so-and-so inquired about the ongoing proceedings. At 12:05, Mullahs, search started in the morning. No seizure took place. Till 12:05, no seizure took place. And inquired about the ongoing proceedings, informed her about the proceedings that around 12:15 took possession of material being seized via laptop belonging to Pratik Jain. Now, laptop belonging to Pratik Jain will have all the information about the election. Every piece of information. Several documents and iPhone Pro belonging to Shri Pratik Jain have left the premises. Several documents. Where are all the devices? He just read in the petition that she took away all the devices. Contradicted by their own Panchnama. An iPhone. She took the laptop which would have the party information, and she took their personal iPhone. That's all, nothing more. And then see for third paragraph. The search was proceedings commenced at 6:20 on 8/1/26 and concluded at 2:50 on the same day. The search was conducted in a peaceful and orderly manner, and no damage to any person or property was caused during the search. The entire proceedings were conducted in the presence of the lady staff and anyway, whatever. There was no obstruction. And signed by ED. So where is the averment in the petition is contradicted by their own Panchnama. Now, Mullahs, what's interesting is there's another Panchnama at 73, because then they go, Mullahs, to the other office, which is at Salt Lake.
Another party office.
It has party material, election material, which you are aware of, which is why you went there. It is a completely mala fide act on the part of the ED to disturb the process of election and to gather as much material as they can from the office, which has all the material, which is through a contract, which contains all the confidential material. Now kindly come to see the second Panchnama. 74 bottom. During the search proceedings, Ishant Taneja, Pavan Verma, so-and-so, and other employees joined the search proceedings. They were also explained the purpose of the visit by the authorized officer. Meanwhile, Shri so-and-so joined the search proceedings. He also offered personal search. Officers started the search proceedings in our presence in a peaceful manner. Nothing was seized. Nothing was seized there. Nothing was seized here. From the premises, and no data backup was taken by the team of Director of Enforcement. And the search proceedings concluded at 6:45 p.m. on H1, documents available in the different sections of the premises were not mingled with each other, and the same was left in a proper and orderly manner. These facts were duly acknowledged. That's it.
Contrary to what you are submitting.
I'm sorry?
They had the intention to collect materials from your party office. They would have seized.
They were just photographing.
They didn't seize anything.
They don't have to seize it. They can
They didn't
photograph.
seize anything.
They can photograph it. They don't have to seize it. But your lordship
Their
knows.
Panchama says they have not recovered anything. If they had
Well, why did they-
any intention
Malaj, what?
of seizing your material belonging to your party,
Malaj,
they would have seized.
we are not discussing.
They have not seized.
Malaj, these are facts which will have to discover, which will have to be dealt with, Malaj, in a writ petition.
We have to examine.
Malaj,
You file counter, we'll examine.
no,
this.
Malaj, just.
No, you cannot restrain us from issuing notice.
I'm sorry, of course I can't, Malaj. I can persuade your lordship, that's all. That's what I'm trying to do, Malaj.
Yes, please.
I'm only trying to show you
Yes,
the Panchanamas certainly demonstrate that there was no untoward things that happened, both at the residence of Jain as well as in the office of ED-I-Pac. Kindly have a look. So the Panchas, Malaj, and the Panchanama doesn't say anything of that sort, Malaj?
Yes, yes.
Right. Now, the other question, one question is, Malaj, and I told your lordships on 24th February 2024, Malaj, the last statement in this coal scam was recorded.
Yes, yes.
Then why was there the need to go in
That's wrong,
2026?
factually wrong.
I have got, you've got I've got it here. Why do you say it's factually wrong?
From
That's
the record
here.
of the investigation.
No, we have it.
Last instance.
We have it here. 23rd
Because
of
unfortunately,
February.
we are conducting the
23rd of February,
No better.
you have given these details to us. Your petition. Your petition, you say that 23rd February, Mukesh Thakur claims he transferred the money to Goa at the request of Jitendra Mehta, a financier of Aks. That's it. After that, no statement. It's your petition.
That is at page.
Para 12 itself, page 104.
We don't.
Just read it.
All evidence at this stage, Manoj.
Ari, you have
Statement
your,
is
I'm
recorded
taking your
in
petition.
December 24.
Again, you are interfering. I'm taking your petition.
Sir, come to page S. 8.
But kindly come to page 8.
Page S.
F.
Page F.
Yes.
S.
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 Okay, I'm sorry.
Which one?
Whatever you give me.
Director of Information.
Yes, you give me.
1 July 2020.
CBI furnished 1720. CBI furnished the second supplementary charge sheet in the proceedings emanated from FIR on 1/7/2024.
Last date, 8/1/26. Concrete material found during investigation.
That's right. So that's precisely the case. That from
January
2020,
26.
that means 2024, why would, what you were doing nothing? Suddenly in 2026, you find material?
On the lighter event, what Mr. Tushar Mehta is suggesting, if money is laundered only during the election, what is their fault?
There is no election, my lord.
That's why this relates to
on a
Goa.
premise that ongoing
Malad,
election.
yeah.
Which election?
Solicitor, you are such a good person. Have the patience to hear us.
My learned friend disarms me.
Malaj, you're right. There is no election in Goa.
Not Goa, this is Bengal.
No, this is where Goa, money transferred to Goa.
My learned friend said during election, why did you
During
go for
election
third?
in West Bengal.
There is no election in West Bengal.
Oh, I see. Malaj, if this is the level of knowledge, Malaj, that emanates from the solicitor, there's nothing I can say, Malaj. That there is no election in West Bengal. I'm sure it does.
He's yet to be notified what he's saying.
Yes.
He can say that, Mullah.
Huh,
He's a very precise lawyer. He's very careful with his words.
I am, my lord. Therefore, I am saying there is no election. Your
There is-
premise is wrong.
Absolutely, there will be none.
And my lord, only one line, my lord.
There will
Allow
be
me
none.
to interrupt.
Allow me,
My lord, if the ED officials go to
Can I
their
argue
party
with
office,
the
it's not a party office,
Can I argue with
it's
the
an office of
respondent?
a strategist kind of a, according to them.
No,
What would a normal person do? Please give me a minute.
Can you? No.
This document
One
second.
have two sets.
One second.
One my party thinks, and another maybe else.
One second. Wait.
Another you can go, but allow me to take my party
Yes.
details.
This-
You have nothing to do with this party
The
details.
solicitor seems to have.
Just takes everything which is shown in the media with files and everything, that I have taken everything. Otherwise, but if there is a scrutiny, say no, this is my party
Everything
document.
that he says has to be accepted. More than that. Why are we here? Merely because he keeps on interfering, says what he wants to say, as if this is the gospel truth. It's not fair. It's not fair on us. Now, kindly see page 38.
1 minute. I'm there in the second petition.
But
No,
you
one
have to
second.
finish here. Let the
Finish that. Allow us
correspondent
to
argue
finish.
at least
Stage
2
of
minutes.
recording of
Allow us
evidence.
to finish.
This is not to be seen.
No,
By ever-
Correspondent argue
ever-
2 minutes at
We
least.
are arguing only first petition.
Very well.
I'm arguing only the first page. Now, kindly see page 38.
Petition you will be allowed to argue.
The second is,
Don't worry.
yes.
Kindly see page 38. Kindly see page 38.
38.
Yes.
You see, there is some circular issued by the Honorable Chief Justice about time schedule.
Yes. You must
Should
fix it.
apply to,
Yes, and interruptions, but both.
to motion hearing also.
Both
To
hearing.
regular hearing.
The moment.
Yes, but the Honorable Chief Justice also should
Apply to.
issue a circular that lawyers who are appearing would not discuss that matter in public forums like press conferences. That is also.
That also, Malaz, that the CBI should not be leaking information and
Yes.
the ED should not be leaking information
Yes. No, there is no, you
surreptitiously
find,
to journalists of their liking.
I am.
Therefore, there should be a ban on that also.
Yes, I'm ready to show, my lord, what I have stated.
You can show it.
Can
You
I-
can show it.
This is not the
Narrative
circular of
building.
That's why
Could also be-
my learned friend always, he's very upset at the fact that I do some program, Malaz. He seems to mention, it's his every matter he mentions this, Malaz. You should watch it a
I'm
little more,
very
he'll
happy
understand a
with
bit. more.
programs. Don't discuss matters. Don't discuss matters which were.
I'm entitled to.
I have not seen
I'm
any.
entitled to.
No,
No, I'm not entitled to. Well, he knows about it.
Mr. Mehta is increasing the circulation of this program now significantly
no, it is.
without watching it himself.
Malaz, page 38. Let's move on to the matter.
Yes, 38. 38.
Yes. Now, what are the offences, Malaz, that are alleged?
Yes.
Yeah, it's all 37, but the offences are all these offences: abetment, criminal conspiracy, voluntary causing hurt to public servant. No such thing. It's on the face of it. In their own petition. Wrongful restraint. No statement of that sort. Wrongful confinement, force, criminal force. What is all this going on? 130, assault on criminal force, obstructing public in discharge, omission to assist public servant when bound to give assistance, disobedience to order duly promulgated, theft in dwelling house, theft after preparation made for causing death, hurt or restraint, robbery, dacoity, criminal trespass and house trespass and housebreaking, house trespass in order to commit offense, causing disappearance of evidence, destruction of documents. What is all this? This is all contrary to what is in the Panchnama. How can all this happen? And Malaj, all this has to be done how? Under 66(2). Under 66(2), if there is any offense, it has to be reported to the investigating agency of the state. Your Lordship knows 66(2). I'll read it to you. How can all this happen in a writ petition in the 32? Can you see 66(2)?
56.
66.
We have gone through that.
Sorry, a PMLA.
PMLA. I saw
Yes,
it,
yes.
866.
Yes, no. 66(2) of PMLA. I read the offences to you just to indicate that all this cannot happen in a writ petition.
No, it has not happened in a writ petition. It has happened there.
No, he is saying these offences have been committed and therefore they have to inform under PMLA if the director or other authority. Just read, Malaj. If a director or other authority specified in subsection 1 is of the opinion on the basis of information or material in his possession that the provisions of any other law for the time being enforced, that is IPC, these are IPC offences, are contravened, then the director or such authority shall share the information with the concerned agency for necessary action, which is the state agency.
FRCBI investigation is
So, Malad, so what they are saying is these offences are committed. They say now you must charge them with these offences. We have filed a writ petition, whereas under the statute they have to inform the agency of the state that such offences have been committed. Please investigate. They can't ask your lordship in an Article 32 to do that. And they are choosing the agency which is being accused by us for mala fide searches. And then, apart from all that, and I let my learned friend take it forward, Manas, apart from all that, Manas, the question is, why should the High Court not hear the matter? High Court is not disabled to hear the matter.
I'll take
So we'll take our submission.
I'll take
But only one
Mr.
answer.
Mayor, please allow correspondent three
And
minutes.
not on the merits. But one response to Mr. Sibbal, a very respected. I personally, you need know, I respect him. My objection to matters of arguments being debated elsewhere is not only against Mr. Sibbal.
It's also
Everyone
it's also against
who appear
yes. No,
in the
that's-
matter
that-
should not give press conferences
My
and
learned friend,
give media interviews justifying or creating a narrative. That's in principle, not in this.
In principle, my learned friend should have no objection. Once a judgment is delivered, it's public property. And this court has said that once it is public property, it can be discussed. And he knows the law, but he doesn't want to reveal that he knows the law.
No, my lord, the incident in question, there is no judgment in law and narrative building.
No, my
is
learned
going.
friend is wrong. There is a.
I leave it at that.
There is a.
No, can I, Minister?
I leave it at that.
3 minutes. I heard my lords, Minister, what my lords.
No, we have the entire, about second half bench is cancelled.
I mean, that matter, Minister, it was mentioned without telling us. That bench, Justice Amanullah and your lordship.
Sir, I do not know your loss, but your advocate on record was
But
informed
then
that
let
he was
me, my
present.
lord is saying something, let me
No,
respond
council
to
has
my lord.
He was present.
It was cancelled by the bench, by the
I see.
court, not by the any
I was
request of
told
any.
somebody mentioned it, he told us
No,
after.
no, my lord, we
Anyway.
mentioned with presence of his advocate on record,
Anyway.
with consent.
What Mr. Singhvi
I
said.
can apologize.
In fact, the court said that we'll fix a date later.
said He should have been heard before cancelling the bench.
No, I should know it.
Understand why?
Yeah, yes.
They have long
Lord,
conference
he can-
that they do and they should
Can
put
Can
on
be
it.
deemed as having been heard, my lord, for all purposes.
Anyway, with this,
So in that bench,
all these
that
digressions.
bench he
let me
says,
come.
2 p.m. bench, that he should have been.
I know
heard
Justice
before
Amanullah's
cancelling the
bench. Anyway,
That it should have been
Let me
recorded
come
in the
down.
order sheet that he has heard. Yes, next. Please.
because people come and have long conferences, discuss matters, and suddenly they mention without telling us. That's why I was
Yes,
complaining.
yes, you are right.
Anyway, brothers.
You are right.
Now I'm going to make 3 or 4 points in less than 2 or 3 minutes, brothers. One is we have serious objections to the maintainability of this so-called Article 32. In the highly unlikely event that your lordship issues notice, your lordship should make it clear as a caveat that it is subject to a very strong preliminary objection on maintainability, which shall be alive.
Yes.
There are judgments which say that an ED or a statutory body like the ED coming straight into a walk-in system of 32 requires very grave consideration. It is allowed in exceptional circumstances where, Malas, it is necessary that the ED is virtually remediless. That's the test. That's point number 1. I propose to raise it, Malas, strongly, both today and in any eventual hearing.
You are appealing for a state of.
I am for 1 and 3, state and
of
police,
West Bengal.
state and DGP. 1 and 3, he's for 2. Point number 2, Malas. I also intend to raise the preliminary objection of forum shopping with your lordship's well-known case law, because what your lordship is concerned about is that this petition is filed after my learned friend files an identical petition. Lordship will take my word for it. The prayers are virtually identical
We are in High Court and.
in High Court and here. Lordship need not waste time seeing it. Lordship will take my broadly, substantially, it's identical.
Yes.
Now you are the petitioner there, you are the petitioner here. Yes, you had a fracas on a certain day, on 9th. That cannot be an excuse to maintain a parallel riding 2 horses.
Why should it happen at all?
No, Malas, that's a different issue. We'll answer that. I understand my lord's concern. And don't think I don't appreciate my lord's concern. I don't think any of us hold brief that should.
Today it is this High Court, tomorrow the.
No, Malas.
Another High Court.
Sometimes, Malas, emotions go out of hand and they can't be controlled. Please don't misunderstand me that I'm not understanding my lord's concern. And that, I don't think anybody will hold a brief. Perhaps emotions go out of hand and we are not able to control. But the relevant test is yesterday.
No, you see, emotions
Yes.
should not go out of hand regularly.
No,
In an
it's not.
orchestrated manner.
And then on 9-1, again, emotions go.
Now, sir, may I just say, we are now talking of R1 and R3. I am saying this, that the relevant date for considering forum shopping is yesterday. I understand, I am not belittling what is falling from my lords. Keep that 9th apart for just 2 minutes. Yesterday, everybody was in court. It is not even your case that anything untoward happened or was attempted or even started. Why on earth, you having filed your own petition in High Court, the next day having filed in Supreme Court or 2-3 days later filed in Supreme Court, then make a statement to the High Court yesterday, please don't hear me, and the High Court is forced to pass such an order, anyhow. It is not that you are getting this date yesterday because of the ruckus. Kindly give a copy now. Why don't you give a copy?
One copy.
So, in effect, the High Court is told, I am riding two parallel horses. I am telling your lordship I am riding two parallel horses. But you please stay your hand. And the High Court records this order, 1-page order. I am adjourning it sine die. Obviously, in Committee of Courts and Superior Court and all that, it's the right thing to do. As far as the High Court is concerned, I am not blaming them. I am on the conduct. So this is forum shopping. I again take the strong preliminary objection. My third submission is the Panchanama, which has been read. That has been read, I am not repeating it, but just note the relevant words, only the operative words, 3 lines, which Lordship has seen, Panchanama, which has been read already. It's been read, but just the relevant lines, at 66 to 69.
66?
Yes, 60 to 69. These words are important. That's my third respectful submission.
That page?
Well, it's at page 60. This particular portion is which page?
8.
68. 68. You also use the first one.
Yes.
Please, you don't go to Hindi. If your lordship had just the penultimate para at 68.
Yes.
This is relevant. Ultimately, what is relevant is this, to tell you that he snatched the papers, he ran away, he did this, he assaulted somebody. What is relevant is this, either you are lying or your petition is lying. Third, penultimate para, second line.
Yes.
The search was conducted in a peaceful, orderly manner. Each word is important. No damage to any person or property was caused during the search. Entire proceedings were conducted in the presence of lady staff and no religious sentiments.
The learned friend may read the 2 paragraphs above.
What peaceful
Two
means?
paragraphs
Peaceful
above.
from their side.
I beg pardon?
They mean to say.
2 paragraphs above what my
From
learned
the
friend.
ED side, not from your side. That is what probably.
I'll read whatever you want me to read, I'll read it, Bullet.
Not the relevant portion. Let him
Yes,
They
yes.
have done it peacefully.
No,
let him read the 2
the
paragraphs.
previous para which he's asking
2 paragraphs
to
above.
face,
My learned
respond,
friend may not
Mr.
do it
Raju,
peacefully.
please.
Let him read.
It is not denied by us.
Dictate Mr. Raju that what he is reading.
We didn't interrupt once even, Malak.
Yes,
It took a long time.
Please, Mr. Singh.
Mr. R2, Mr. Sibbal, has admitted that the CM was, the president of the party was there. So what is so great about this para? This para says that so-and-so time, so-and-so Miss MB took possession of the material, etc., etc. That's all. Nobody is denying that she was there. Now, these are derailment. I have a different point. I am saying that with this Panchanama, what you are projecting in the petition is either clearly false or your Panchanama is false. That's all I'm saying. This para is standalone, clear. Obstruction, could not do this, could not do a search, all wrong. Now, the fourth aspect is very important. My learned friend, I heard Mr. Mehta making what again is I can ascribe to blindly to wrong instructions. He said we informed them, and I believe I heard the word yesterday. The day before the event happened. I may have been wrong, I may not have heard you correctly, in which case I'm wrong. Well, it's the first and only intimation came from a casual email at...
Email can't be casual and non-casual. That's what the intimation was by email.
Have you heard my sentence fully? No, have you heard my sentence? You realize? You don't be presumptuous, Mr. Mehta. You started your search at 6:45. The email is 11:30. In which calendar, from which Gregorian or non-Gregorian calendar does 11:30 happen before 6:45? I'd like to understand that. So before you interrupt, get your instructions right. That's why I said, obviously, if I'm searching his house and I send an email at 11:30 to create a paper trail, I started searching the house at 6:45, 5 hours earlier. And my learned friend says it was beforehand informed. In the middle of the persons are there, some police officer will go start reading emails. 5 hours earlier, event has happened. So this is a very clever way to cover up your tracks. A person who sends an email at 11:30 for a search which starts at 6:30 is covering up his tracks, creating a paper trail to tell your lordship later on. My next point is, that the question he raised, I'm only answering that, but I'll have to put it down if necessary. I came there because a Z protectee, a Z class protectee, was informed in an FIR number 5 of 26 that unidentified persons who refused to identify themselves had entered this place and were dealing, and the Z class protectee had reached there. So naturally the police rushed there. That's all that happened. Now, the ED officials identified themselves much later. They did not identify themselves because the only identification would be a prior written intimation at 6:45 that I am Mr. A, Mr. B, Mr. C, we are going there at this time, or at least just before that. So, that is why I went there. That is nothing sinister about that. And whether she is a chief minister or a president of a party, she remains a Z plus protectee. So, the moment we come to know, we have to move. Well, in the light of this, your lordship may consider, I leave it to my lords, that we put in, if your lordship is so inclined, without notice also we can put in a reply saying these points. Otherwise, I leave it to my lords.
Otherwise, you will say 6:25 p.m., 11:30 p.m.
No, I will put in these things. If your lordship wants me to put
Legal
in.
things should
So
be
there
done
are
in a
other
legal way.
respondents also.
Should be done in a legal way.
Anyway, I don't know. That's all I have to say.
Yes. Yes. You're for?
I'm appearing for respondents 4 and 5.
Sorry.
In first petition.
Yes,
Because we are yet to hear the second petition.
it's in both the
No, Mr. Raju wants to argue the second petition.
first petition.
First petition, respondent 4 and 5.
5, yeah. So I just have a very small point. Your lordships may just consider that the appropriate order, perhaps in a case or a situation like this, your lordships have seen that the hearing which took place on the 14th was in a very orderly manner. So I would respectfully submit that that is the subject matter of a 226 petition. Let that matter proceed. The lordship wants to reinforce because the Chief Justice's directions are very clear. It's proceeding in an orderly manner. It ought not to be, that's my suggestion, that the 9th January disruption which took place when the court itself could not hear the matter, that shouldn't have a lingering effect which persuades this court to issue notice under 30. So let us see what happens, my lords, on the adjourned date or the next date as far as the 226 is concerned. If that proceeds smoothly, as it will, I mean, we expect that it will, that's a much better way of going about it, my lords, rather than this. I would respectfully submit that statement, at least at this point.
Yes, Mr. Raju.
There are several submissions that I have to make. The first submission is the recording of an FIR only requires that prima facie a cognizable offence is made out. If the averments in the petition make out a prima facie case that a cognizable offence has been made out, that's the end of the matter. Lalita Kumari is very clear. No inquiry is required, no accused is required to be heard. The defense is not to be
You
considered
are
at that
speaking
stage.
about which FIR?
I'm asking for the FIR, which I'm asking to be registered and CBI investigation.
Oh, yes.
For that, I'm making my submissions. So if my petition discloses a cognizable offence, then a FIR has to be registered. Nobody hears an accused before an FIR is registered is unheard of. We have made them respondents by way of abundant caution. That is what we have said without conceding the right. That is my petition says. I've said that in paragraph of my petition. I'll read that paragraph. This is one paragraph. Now, therefore, the issue that arises is, has a cognizable offence taken place? On admitted averments, the offence of cognizable offence has taken place because an offence of theft. I have pitched my case a little higher. It is not only theft, it is robbery and it is dacoity, because more than 5 persons were there. Some policemen were armed and there was wrongful restraint. But forget that. simple case of theft, which is a cognizable offense, is made out on admitted averments in my petition. If that is so, the issue is who should investigate. If a cognizable offense, FIR has to be registered. That's the settled law in Lalita Kumari. May I read Lalita Kumari or
Yes, read.
give me Lalita Kumari? Come to back. Kindly.
You can continue.
I'll not take much time, but I'll only make, kindly have a look at para,
You argue, we have no difficulty.
or kindly have a look at para 120 onwards, conclusions.
Yes.
By
Para 5.
120
Para 120.
at page 61. 120.1. The registration of FIR is mandatory. Kindly note my mandatory under section 154 of the code. If information discloses commission of a cognizable offence and no preliminary inquiry is permitted in such a situation. So if the petition discloses a cognizable offence, it is mandatory that an FIR has to be registered.
Para 120.1.
Yes. I have demonstrated that a cognizable offence has taken place. One doesn't say that you have to inquire from the accused why you have committed the offence of theft. That is not the scope of registration of FIR. You have to look at the averments made by the informant, in this case in the petition, and if it prima facie makes out a case of theft or a cognizable offence, FIR has to be registered. Therefore, whatever they are saying, we went there because of a party document, which is wrong. Otherwise, no FIR would be registered. The entire purpose of the scheme of the CRPC would be frustrated. This is number one, Manoj. The second is, ordinarily, I have to go to the local area where the offence has been committed to get the FIR registered. But this case stands on a different footing. Your lordships have permitted deviations from the normal rule. Why the local police should not be permitted to investigate? Here, the chief minister is an accused. She is the person who has personally committed the theft. This theft was committed in the presence of the Director General of Police, who could be an abettor. It has been committed in the presence of the Police Commissioner of Calcutta, where the offence has taken place. So, head of the police in West Bengal is accomplice as far as the offence is concerned. Police Commissioner is an accomplice, and she is the Home Minister. So, no FIR, if it is registered, even if it is required to be registered, will be inquired and investigated properly. Now, the law is, kindly have a look at three judgments. In this case, if the highest authorities are involved, then the CBI investigation is to be ordered. But kindly have a look at, one is KV Rajendran versus Superintendent of Police, 2013, 12 SCC 480. 480.
480. Para?
Yara would be 17. Where they say if the
70.
17. It is extracted at page 31 of my petition, Manoj.
Page 31 of your petition.
Yes, of the first petition also, my lords, we can have a look at it.
Then,
In view of the above,
page 480.
page 31 of my petition, My lordship got it?
481.
480 para 17, my lord.
13, 12.
I can hand over a copy of syllabus.
No, we have
In view of
para 17.
7.
In view of the above.
In view of the above, the law can be summarized to the effect that the court should exercise its constitutional powers for transferring an investigation from the state investigating agency to any other independent investigating agency like the CPI only in rare and exceptional cases, such as where high officials of the state authorities are involved, or the accusation itself is against the top officials of the investigating agency, thereby allowing them to influence the investigation, and further, that is so necessary to do justice and instill confidence in the investigation, or where investigation is prima facie found to be taken. This is at the stage of investigation, but prior thereto also it can always be exercised. Then kindly have a look at the second judgment, my lord, 2014, 8 SCC, page 682, para 86.
Oh, then 14.
2014, 8 in SCC, page 682.
Last but one page, just for easy reference. Last but third.
It is the para 86, Supreme Court page number is 736. It starts like the criminal justice system mandates that any investigation into the crime should be fair in accordance with law. So if it is investigated by the accused or somebody subordinate to the accused, it can never be fair.
Yes.
In accordance with law, it should not be tainted, it would be tainted. It is equally important that interested and influential persons are not able to misdirect or hijack the investigation, which would be the case if the local police are asked to investigate, so as to throttle a fair investigation, resulting in the offenders escaping the punitive course of law. These are important facets of rule of law. Breach of the rule of law, in our opinion, amounts to negation of the equality right under Article 15. Therefore, my lord, I can come here directly, because otherwise my right under Article 32, fundamental right under 14 would be infringed. Therefore, I can come directly to this honorable court, even under 32. No need for me to go before the High Court. Then, my lord,
Why can't you continue in the High Court?
I'll tell my lords why.
You answer it after we come back post lunch.
Very well, I'll answer.
Articles 131 to 139, which define that jurisdiction. Please mark, my lord. Article 32 provides a guaranteed remedy for the enforcement of those rights, and this remedial right is itself made a fundamental right by being included in Part 3. This court is thus constituted the protector and guarantor of fundamental rights, and it cannot, consistently with the responsibility so laid upon, refuse to entertain applications seeking protection against infringement of such rights. No similar provision is to be found in the Constitution of United States, etc. Lord, here the officers are also before your lordship seeking their Article 21 rights, because there are FIRs filed by the local police and they are threatened with, my lord, their freedom under Article 21. Apart from, my lord, my lord, jurisdiction, my lord, on behalf of the victims of money laundering, my learned friend.
Kindly have a look at Article 226, sub-article 4.
226.
226, sub-article 4. The power.
Yes.
The power conferred on a High Court by this article shall not be in derogation of the power conferred on the Supreme Court by Clause 2 of under Article 32. So this, according to me, is the issue. 32 powers are protected even under 226, as by the Senior Solicitor General had said, it itself is a fundamental right. There have been cases where your lordships have transferred investigation to the CBI in exercise of powers under Article 32. I may give one or two judgments by way of illustration. I see. Kindly have a look at para 80. And 82.
80.
80. This has been done in exercise of powers under 82. I may just leave it. But in a given case, your lordships may come to a conclusion that it warrants not only investigation by the CBI, but it warrants investigation to be done outside the state. In a given case, if it is to be done outside the state, 226 powers cannot be exercised. One judgment, my lord, to para 89. All that. I leave it to that extent. Therefore, now as far as the
Yes.
ED officials are concerned, my lord, 4 FIRs have been filed against them. Kindly have a look at section 67 of the Prevention of Money Laundering.
Which provision?
67. No suit
Yes.
shall be brought in any civil court to set aside, modify any proceedings or order made under this act, and no prosecution, suit or other proceedings shall lie against the government or any officer of the government for anything done or intended to be done in good faith under this act. So the search proceedings were done under good faith under this act. Therefore, the prosecution, the FIRs are not maintainable. They're hit by the bar under 67. Despite that, to put pressure on us, these 4 proceedings have been filed. Therefore, I have read separately for stay. Order of stay may be passed, notice may be issued, and the matters may be heard. So all that I
We are praying for stay of the FIR against us. The ED officials are facing FIR filed by the local police. My lord. These are, my lord, the FIRs. We have made, my lord, the everments, we have given the details, and we have prayed, my lord, in prayer F. My lord.
Yes.
And they are constantly filing new FIRs. But that has been a pattern, we have seen. Lord, page 126 is the prayer clause.
Let us see the prayer. Prayer is
Page 126. page 126.
No.
E, capital,
Main matter, page 46.
126, my lord. Main relief, your lordship, yes. Issue a writ of mandamus directing the. No, your lordship wants the entire prayer clause, my lord, to be read,
Just a minute.
or the interim.
What are your, yes, interim.
Interim is page 126. My lord, where right now, my lord, I would be subject to your lordship, my lord, being persuaded, praying for E. In the meanwhile, your lordship gets direct stay of the FIR number so-and-so registered at Shakespeare Sarni, FIR number so-and-so, and any other FIR registered against any officer of the Enforcement Directorate with respect to the searches conducted on 8/1/26 during the course of investigation of coal scheme, etc. So we have restricted our prayer, my lord, to this incident.
What is this past interim direction commanding the respondents to preserve, deposit, and provide a CCTV camera as stored?
Yes, my lord, that should be preserved, my lord. Let it be with the registrar of this court.
No, right now you are praying for E only.
E. But, my lord, if, my lord, your lordships are persuaded, my lord, C also, my lord, A. Interim directions commanding the respondent to preserve, deposit and provide the CCTV cameras and storage devices containing the footage of both the premises search on 8/1/26 as described, and not to make any deletion.
Just take. In these two writ petitions, referred by the Directorate of Enforcement. Oh, yes, in the first writ petition, the petitioners are Directorate of Enforcement and its Deputy Director. Whereas in the second writ petition, the petitioners are
They're the assistant directors and the persons who were named party to the search, and they've been named in the FIR as accused.
are the officers of the Enforcement
One is
Directorate.
the IO of the case.
Enforcement Directorate against whom?
Nobody is named. I'm sorry, nobody is named.
Huh?
No, they are not named, but they would be.
They went for the search, and the officers who conducted search without naming them are the FIR.
Who had gone to the premises, subject premises, in course of investigation conducted by the ED. Learned ESG, appearing for the petitioners, would draw our attention to the series of events which has led to the filing of the present writ petition. According to him, the ED was investigating a scam amounting to rupees 2,742.32 crores since the year 2020, and in course of the investigation of the said scam, intelligence was received that about 20 crore of proceeds of crime from Kolkata to Goa was transferred through R. Kantilal firm, and which has eventually channeled into ED-I-Pac's operational framework by being handed over to persons executing the work. executing its work. Armed with authorization to carry out search and seizure proceedings at the residential premises of Mr. Prateek Jain of ED-I-Pac, the officers visited his premises on 8/1/2026. Visited his premises, comma, amongst other premises, comma, on 8/1/26. And when the search was going on, the Manoj Kumar Verma, IPS, the Commissioner of Police, Kolkata, first entered the premises. Dr. Sri Priyabrato, IPS, Deputy Commissioner of Police, comma, Sri Manoj Kumar Verma, IPS, Commissioner of Police, Kolkata, entered the premises, and thereafter, the second respondent in WP number so and so, the sitting Honorable Chief Minister of West Bengal, Ms. Mamata Banerjee, also entered the premises despite making categorical request for not interfering with the ongoing search proceedings under PMLA. Full stop. He would submit that this is not the singular incident where Honorable Chief Minister has entered the premises under investigation by the ED, under investigation, comma, as on an earlier occasion when the CBI was investigating an offense, the similar event has happened. Therefore, there is a pattern of interference with the investigation carried on by the central agencies. According to him, comma, the materials collected by the ED officers were taken away by the respondents in an illegal manner. And thereafter, the West Bengal police have registered FIRs against the officers of the Enforcement Directorate. Lord SG would submit that in a situation like this, comma, it is difficult for the central agencies to carry on investigation which has connection with a huge scam running into so and so, 2,700 so and so crores. Learned Counsel would submit that true it is that the petitioner ED has prepared a writ petition before the Calcutta High Court, but when the matter was to be taken up for a hearing on 9/1/2026, the legal cell of the Trinamool Congress sent message to its member on WhatsApp calling them to assemble in the court. And thereafter, what has happened in court has been recorded by the learned judge in its proceedings dated
Page 121. 121. Order in
dated 121, which is reproduced hereunder. Para. On the above basis, Learned Counsel would submit that Learned SJ would submit, firstly, that the present is a serious matter which needs to be examined by this court, and secondly, the High Court is not allowed to proceed further Full stop. According to him, comma, since high police officials of the state government are involved, comma, it would be appropriate for this court to examine the issue in the larger interest of justice and to set and full stop. Learned ASG Sri S.V. Raju, appearing for the petitioners in the other writ petition, would submit that recording of FIR in a cognizable offense is mandatory in view of the law laid down by this court in Lalita Kumari 2014 volume 2 SCC page 1. Full stop. According to him, comma, when the Honorable Chief Minister and the Director General of Police are involved in the matter, comma, it cannot be expected that the police officers subordinate to them would conduct the investigation in a fair manner. He would submit that the present is a case where the offences committed by the respondents should be investigated by the CBI. He would next submit ऊपर वाला जहाँ SG का लिखा है Sri Kapil Sibal, learned senior counsel, appearing for the respondent number 2 in first writ petition, and Sri Abhishek Singhvi, learned counsel, appearing for the respondent number 1 and 3.
Yeah.
1 and 3 would submit that the present petitions are not maintainable. He would submit that there is a pattern of interference by the ED in the name of investigation exactly at the time when elections are due. They would submit that when the matter is pending in the High Court, the present petition under Article 32 of the Constitution of India may not be entertained. Taking us to the materials on record, particularly the Panchanama available at page 66, it is pointed out that nothing material was recovered during the search and the seizure. It is also argued that the local police officials were not informed by the ED before initiating the search in the morning of 8/1/2026. Sri Sibbal would particularly submit that the respondent number 2 had not gone to the place of incident in the capacity of the Chief Minister, but C, being the chairman of Trinamool Congress, had gone there on information that certain unauthorized persons have entered into the premises of Mr. Pratik Jain, who has been entrusted with party's election work. According to Mr. Sibbal, there was nothing available in the office of ED-I-Pac except some election-related documents with which ED has no concern, and they should not have entered the premises. Full stop. The Sibbal would also submit that the respondent number 2, being the chairman of the TMC West Bengal, it's a national party, by TMC, is a jet protectee, is also a jet protectee. This is your argument. Mr. Singhvi will submit it. Singhvi would submit. So it is a jet protectee. Therefore, it was the duty of the Director General of Police to accompany her when she entered the premises of Mr. Pratik Jain. Full stop. Sri Shyam Devan, learned senior counsel, appearing for so and so, correspondent number 4 and 5, would argue that when the that it is factually correct that some untoward incident happened when the High Court proceeded to hear the matter on 9th January, but thereafter, on 14th January, the matter proceeded peacefully but has been adjourned at the request of the ED. Therefore, this court should wait for the outcome of the proceedings pending before the High Court. Para. Having heard learned counsel for both the parties, we are of the prima facie view that the present petition has raised a serious issue relating to the scope of the investigation by the ED or other central agencies and its interference by state agencies. Full stop. According to us, for adherence of rule of law in the country and to allow each organ to function independently, it is necessary to examine the issue so that the offenders are not allowed to be protected protected under the shield of law enforcing agencies of a particular state. Full stop. According to us, larger questions are involved, has been raised and are involved in the present matter, which, if allowed to remain undecided, would further worsen the situation, and there will be a situation of lawlessness prevailing in one or the other state, considering that different outfits are governing at different places. Full stop. True it is that any central agency has no power to interfere with the election work of any party, but at the same time, if the central agencies are acting bona fidely to investigate any serious offense, the question arises as to whether in the shield of taking shield of its party activity, the agencies can obstructed in carrying out their investigating power in a bona fide manner. Full stop. Para. Issue notice to the respondents. Let counter be filed, counter affidavit be filed within 3 days. Can you file it within 3 days?
Not possible.
Within a week. Within a week.
It's some time, at least 2 weeks. Maybe minimum 2 weeks.
2 weeks. Then we'll preserve all the material. If it takes longer time because the digital
Not
evidence.
preserving, Maharaj. Your losses make
Yes.
no issue on that.
Yes,
This is not going to be
in
the
2
authority.
weeks.
2 weeks.
Post the matter on post the matter on 3rd February.
Lord, prayer A and E.
Full stop, full stop. In the meanwhile, it is directed that the respondents shall preserve the CCTV cameras and other storage devices containing the footage of both the premises searched on 8/1/26 as described in the writ petition and the CCTV cameras and storage devices containing the footage of nearby areas. Now what it is to this? No, investigation. And the CCTV 8/1/26 full stop. It is also directed that the further proceedings and the investigation relating to FIR number 3 of 26, 4 of 26 and 5 of 26 registered at electronic.
There is one more, 7 also, Lord. I have placed on record.
It is there in the main petition, but not here.
In the additional document, it was filed
7 of
subsequent.
26 registered at electronic PS, Vidhan Nagar.
Lord, there are 2 from Shakespeare Sarni.
Just name the police station properly.
Lord, it's in E. E has, my lord, the police station, page 126 E. 2 are, my lord, from Shakespeare's Sarni, and 2 are from electronic PS Bidhannagar. The index, my lord, in the present,
In just IA.
yes,
Direct
it's a document compilation.
is also direct that FIR number 3 of 26 and FIR number 4 of 26 registered at police station Shakespeare Sarani and FIR number 5 of 26 and 7 of 26 registered at Electronics Complex PS shall remain state till the next date of hearing.
Or any other FIR pertaining to this.
So we may not be aware of.
This is
We
not
do
like
not
a
know.
blanket order.
There should be clarity in our order.
Yes,
You
sir.
can't say that any other this
No, I understand.
this is not proper.
Great.
Whereas I have one request, for you, just Lordship consider it. Whereas normally a Lordship does not stay investigation. No coercive steps will be taken is an alternative.
No. You see, in view of section 67, if they were armed with a letter of authorization, they were acting in good faith.
So I'm only saying, well, investigation without any coercive steps.
Mr. Singhvi, you
No.
understand the delicacy of the matter.
It's got equally well,
If you
delicacies on
proceed,
both sides.
if you proceed with the investigation in any manner,
Whereas
then
without
it will be
any
difficult,
coercive
but
steps.
then we will.
Without any coercive steps.
No, my lord,
In any manner.
that may not.
Secondly, Willis, if your Lordship is granting a stay on investigation, then let us have more time to reply, Willis, because then there will be a complete stay of investigation. Let us take out all.
No. 15
There has
days
to
is
be
enough.
more.
What more you want?
Willis, maybe 3
In
weeks
fact,
or
this
4
order could have been passed after 10 minutes of hearing. We indicated to you that we are inclined to issue notice. But since both the parties have raised that much of argument, it is necessary for us to record also.
Because,
Because
be a little
nowadays it is aired, everything.
now
And
that
then
it is,
everybody will say that court has
Now
not
that it is
recorded anything,
stayed,
so much was argued.
now that Lordship has stated, little more time can be given. That's
Yes, next case.
My lord, the IA for addition of party, for chief secretary and others are being joined. And my lord, prayer for
Chief Secretary.
suspension. No, suspension power is with the chief secretary.
That's suspension.
That's my prayer. That's my prayer.
We file a counter.
That's my prayer, my lord.
Let's
strongly opposing this kind of running of
Notice may be issued.
let counter to IA number so and so
Yes,
may also be filed.
yes, yes.
It's not even listed, Malad. It's not even listed.
No, it's given, my lord. Copy is given.
It's
There.
got.
I have tendered
These
it.
are the strange
You
procedure.
kindly list it tomorrow, my lord.
Whatever
Let
it
them
is,
file a
it's
reply.
not
I will not
listed.
get the relief today.
Just not.
You only file counter. We are not saying anything. No passing
Yes.
no orders on that.
We'll file counter.
We'll file.
Passing no orders on that.
Malad, if we filing counters in applications, then the main matter, Malad,
There are only two main
There's
matters.
so many matters there.
No, only one matter in application.
Let's
That's all.
let counter to IA number so and so. Which are those IAs?
We'll give the number.
It's not
We
numbered.
file before the next date of hearing.
Yes.
Yes, next.
Item 28.
ये
Right.
हमारे notes का इस production है.
G.
20 connected. 20 is connected.
Huh?
20 is connected.
Yes.
It says complete must.
29.
Yes, next.
Well, let's in this matter, this is for anticipatory bail. Now, he has no criminal antecedents whatsoever.
You impersonated this.
That is the allegation on the basis of statement which is made in police custody. Now, between
You have said in one of the ground
yes,
that settlement agreement
that's right, my lords. We
has
can
been entered into family members of other person with the complainant.
that is on record at page 60. So the money has now been given to the vendee.
Yes.
Page 60.
On the ground of settlement.
Yes. Okay. Ms. Tika Devadi, learned counsel for the petitioner, who submits that the petitioner was not named in the FIR, and as a matter of fact, in matter of fact, which is that page?
Page 60.
No, 60 is something different. Bail application.
No,
Where is that agreement?
page 44. Sorry, I'm so sorry, my lords. The settlement agreement is at page 44.
As a matter of fact, tell me.
Okay. In council का नाम, the only council petitioner would submit that petitioner was named in the FIR, and as a matter of fact.
And as a matter of fact, the complainant and co-accused persons have already entered into a compromise, and the entire amount in question has been refunded to the complainant. Issue notice returnable on 10th February. In the meanwhile, petitioners shall not be arrested in relation to crime number so and so, police station so and so, offences under section so.
Very good.
Yes,
What should pass over? madam?
pass over.
Item 1.
Wait, please look. Lord, at the time of issuance of notice, Lord, your Lordship had directed me to first surrender, Lord, then granted specific liberty to file for suspension. Lord, this is
Yes, Mr. Sharma, this is an offence of 1992.
That's correct, Lord. I understand that situation.
Now, after 1992 means 36 years, he sought to be arrested, needs to be examined. Considering that the offence was committed on 29/8/1992. That is more than about 36 years back. And presently the petitioner is in jail from 18/8/25 after he surrendered before the trial court. We are inclined to suspend the sentence and release the petitioner on bail.
Lordship may say in the facts of this case, because he has not undergone even 1/4 of the sentence.
Therefore, considering the facts and circumstances of this particular case, we are inclined to suspend the sentence and release the petitioner on bail. Accordingly, it is directed that on petitioners furnishing, therefore, it is directed that petitioner shall be released on bail on such terms and conditions as may be imposed by the trial court.
Deeply well. Very good.
Post the matter, records have been summoned.
No, Lord, not yet.
That record of the trial court be summoned and the matter be posted. The matter be listed on 6th April.
Very deeply well. Grateful, madam.
Yes.
Lords, passed over item 5.
Please, Lordship.
Password.
Yes, this is that matter where the cost.
I appeal for the
Only about cost.
the notice was issued to the limited aspect.
Yes, yes. Leave granted.
Yes, sir.
Under the impugn order, the High Court has quashed the notice issued by the Additional District Magistrate Hapur in so and so ये अपने order में लिखा हुआ है 28/11/25. There are two matters.
Yes, no, same, exactly the same order has been passed.
ये देखिए दो केस नंबर लिखा है, एक एसएलपी का एक केस नंबर है, एसएलपी का दूसरा केस नंबर। ये कॉमन ऑर्डर है करके दोनों का एक साथ लिख दिए। अच्छा, दोनों का कॉमन ऑर्डर ही बनाओ। कॉमन ऑर्डर so and so in case number so and so, full stop. While quashing the notice under challenge before the High Court, a cost of ₹20,000 has been imposed on the state of UP in each of the case, further reserving liberty in favor of the state to recover the same from the concerned additional district magistrate. Having examined the matter, we do not find that the High Court has recorded any finding that the concerned additional district magistrate has passed the order which was under challenge before the High Court in modified exercise of power or due to any extraneous consideration. In such view of the matter, imposition of cost of ₹20,000 and directing the same and reserving liberty in favor of the state to recover the same from the additional district magistrate is not justified. Accordingly, we quash the said part of the impugn order imposing cost of ₹20,000 on the state.
What's the question of law and that would be left open in other matters also because that
We have already dismissed that part. That part is already covered in our order issuing notice.
Very well.
Yes.
Deeply aware. My lords, this
Am I
order-
audible? My lords, am I audible?
Yes, yes.
My lords, this is a transfer petition by a wife who is based in Kanpur, and she's seeking a transfer of the Section 13A petition from Gwalior to Kanpur, my lords, which is approximately more than 300 kilometers far. Now, my lords, also see annexure 4 of my petition, my lords, there was a different matter way back in 21 involving the similar parties, in fact, same parties, which was also transferred to Kanpur from Gwalior. Annexure 4, Maulats.
Page?
Page 38, Annexure P4.
Yes.
This is the order of the Supreme Court, Maulats.
It's our order. Then let it go to this same place.
Manoj, there are
Yes,
a few
Manoj.
solutions in this matter.
Yes.
Prior to the mediation, we were informed that they are willing to settle the matter. We took the matter into mediation and they
Manoj.
informed us that they would be willing to settle with the
Manoj.
amount that we stated, right? We stated that the settlement should be arrived at an amount of 10 lakh rupees.
Maulats,
They now increase
they
that.
never offered 10 lakhs. They
Went to
initially
30.
offered 18 lakhs.
The child is in all.
Just 1 minute.
They've now increased that amount. They went to 30 lakhs just to settle the matter. Now they also have the custody of the child. I am paying. Why the order dated why an order dated?
This is only a transfer petition.
Yes,
This is
Manoj,
a
but
transfer
they're
petition,
seeking to
Manoj.
harass us in the mediation.
Manoj, this is very unfortunate that a man
They kept
who
on
is so
saying that there are
self-centered,
more
he's
cases which are about to
hardly
come.
bothered about his son, Manoj. He's not ready to pay anything. We offered him to create a FD
Manoj,
for
I'm
his son. He
paying
refused.
maintenance since 2024. That maintenance
He's
amount
not
has
willing to pay
also
a single
increased. They
penny
have
for
the
his child,
custody of the
Manoj.
child.
Considering that on an earlier occasion, this court has allowed petitioners TPC number 2840 of 22 and transferred HMA number 543-A of 2020 from Family Court Gwalior to Family Court Kanpur City, the present transfer petition deserves to be allowed so that the cases pending between the parties are tried at Family Court Kanpur. Accordingly, the present transfer petition is allowed, and so the prayer classes are there. It's tough. Yes.
Much obliged, Manoj.
Item 14.
Yes.
This is a transfer petition filed by the mother-in-law, husband, brother-in-law.
Mother-in-law. Transfer petition by mother-in-law. Deviate.
We all are the petitioners here. Husband, brother-in-law, mother-in-law, age 80 years, and sister-in-law, and a relative is 71 years.
It is from Visakhapatnam to Mumbai.
Please, Lordship. More importantly, that the
why deviate proceedings initiated by the wife should be transferred to a place where the husband is residing?
No, but Lordship, my problem is that kindly see page number 56. We are represented by the lawyer there, but the court learned ACJM
wants you to appear. You appear, husband, others may be exempted.
That's all.
But I have no problem so far that is concerned. Because this transfer petition appears to be filed on a premise. They appear to be aggrieved only by the reason that they've been asked to appear personally. Because if that is the grievance, they have a remedy to file an appeal. Because there is no other ground stated in the transfer petition for seeking transfer. But I stay in Visakhapatnam with my 4-year-old daughter, Malaj. It is not possible for me to travel. And 498A trial is already going on there. They are appearing there. They are appearing in this one also through their lawyers.
On hearing learned counsel for the parties, we are not inclined to allow the transfer petition seeking transfer of the proceedings under the Domestic Violence Act initiated by the respondent wife. However, we direct that the trial court, that is the 4th Additional Chief Judicial Magistrate, Visakhapatnam, Andhra Pradesh, shall not insist on physical appearance of the respondent.
Well, let's consider saying the other respondents. So the husband can appear, the other respondents will be exempted, subject to what my lord says.
Respondent of the relatives of the husband.
That's right.
Unless their physical appearance is mandatory on any particular date of hearing. Lordship.
Lordship, they can join through VC, Lordship.
That's
They
what
can
my
join-
lordship says.
The relatives of the husband shall appear through video conferencing on such dates where their physical appearance has not been directed by the court.
Grateful, Lordship. Absolutely.
Yes.
Great.
Item 21.
But this,
Yes,
this petition, my lord, caveator is present here. It was passed to.
caveat,
Caveator is present
eviction,
from a shop, my lord, in Delhi.
market,
Please, your lord.
Khan market.
450 square yards.
2017 eviction, 18th March 2017, and you are resisting.
No, I'm not resisting, my lord.
Then who is resisting?
I'm not resisting. I just filed a revision. That's all. In the Delhi Rent Control Act, there is no provision for an appeal.
Means resisting in a legal way.
Yes, that way.
Not
not,
physically.
not in any other way.
Yes, yes.
Not under the Delhi Rent Control Act, there is no appeal.
Time, how much time?
No, your lordship, just allow me.
You say there was an oral agreement
No.
to sell.
My lord, I've got the material.
Honoring his oral agreement for last so many years.
The material is
Not
there on
selling it
record.
to the person with whom he has oral agreement.
Lord, may I just, your lordship, just allow me about 2-3 minutes, and then I won't take a lordship more below that. Lordship, I'll just refer to my written statement, where I said so that all these facts, that they had agreed to sell this property to a person through so and so. In the replication, they admit it. They admit that they were dealing with this man, but they changed their stance and they said this was only to in order to enable him to change the nature of the property from leasehold to freehold. This is their stand. When the document comes, the document comes, it says permission to sell. I just point that to your lordship. P2. Lordship may just have P2. Lordship may have P2, and then I'll also. It is permission. Lord, P2 is at page 68. Page 68. Lordship may see the title of this. P2, page 68. Permission for sale of shop number 30A, Khan Market. So what they say eventually when he comes in cross.
2010.
Yes, sir. But this is during pendency of the rent petition.
And
this
you are a tenant since?
Since 1975.
Then it will happen. Out of frustration, the landlord will.
No, my lord. It's not out of frustration. When they gave it to me, that was the market rate. It's a different matter. Market forces have changed. It's a different matter. Now I'm paying 2.5 through court.
It always happens. The
I'm
landlord
paying-
feels after 15,
I'm
20
paying.
years.
So here they want to sell it. Then come, Lordship may allow me to refer to.
You see, this particular area,
Please.
it is the costliest
Yes.
in the Asia, or I do not know where. Some news I have read.
Yes.
This Khan market.
Lord, now it at one time it was. Now it seems to have lost its sheen. This area has lost its sheen now.
It has not lost its.
It's only now an eating place where everybody goes for their restaurants, more restaurants
I
than.
do not know whether it is eating or something else.
It's more like that now.
But it is
Market
very
is
popular.
famous for that.
It is very popular.
Yes, sir. Therefore, he wanted to sell
For
it.
multiple reasons, it is popular.
Therefore, my lord, the idea was to sell it. And now, unfortunately, under this act, my lord, this is a strange act. It doesn't even have a provision for an appeal. There's no provision.
The only ground
Yeah.
to issue notice in your case is that Mr. Siddharth Dave is appearing
That is good enough, Lord.
for the landlord, leaving all his bail matters and bail matters.
That's why I had to take a pass over. I'm very sorry, man.
And my lord, a caveator got a pass over. That's good enough reason. We've all been waiting. Lordship,
Same time, 6 months, 8 months.
Lord, statutorily there are 6 months. The court says I will not even grant you that. Please leave immediately.
2017, you were allowed 6 months.
Lord,
Several 6 months have
Lord,
gone
after
past.
that I had a right to file a revision. There was a stay order in that revision, and then I've been paying money as per the market rate.
Now we can allow further 6 months. We can allow further 6 months from today.
Lord, could your lordship just consider increasing that amount of days? Why? Because it's a shoe shop.
Amount of-
I have to sell off
Amount of
the time.
No.
I have to sell this entire material there. I have to sell this entire material. I'm not shifting to another place.
And
I will shut down the business.
He owns the shop which is next to it.
But I will not.
Next to this shop, he owns a shop which is let out for 8 lakhs of rupees. And I am 2.5 lakhs. He has to shut down his business.
Not.
This is not fair.
There's nobody ready to take on
At
the
least
business.
my learned friend should be fair.
After upon hearing learned counsel for the petitioner and learned counsel for the aviator, we are not inclined to entertain this SLP. Accordingly, the SLP is dismissed. However, considering that the subject premises is a non-residential premises, we allow the petitioner to occupy the same for a period of 6 months from today. Post op. Accordingly, the SLP is dismissed and the petitioner is directed to hand over vacant possession of the subject premises on or before on or before today is 15th.
Gotcha.
On or before 16th of July 2026.
He can pay that amount.
Petitioner shall file usual undertaking before the registry of this court and also continue to pay the monthly rent
It was fixed as user charges, my lord.
user charges
As assessed by the High Court one.
as assessed by the High Court. Yes. Next.
I'm ready for you.
Your lordship consider 2 months more. Lord, we have to sell this stock.
What you will do in 2 months?
We have to sell this. Not this is all shoes which I bought from people.
Yes.
We have to sell them.
Miscellaneous matters completed.
Miscellaneous completed. Regular matter will not take. We are not taking up.
One small request. One small request in 101.
Yes.
Just a small request in 101, my lord. Lords had directed us to file one of the deposition which was not filed by us. But there has been some technical glitch we have not been able to file. Carrying up, my lord, may kindly give me fresh direction so that I file that in the counter physically.
Both of them are so happy when he said these two.
Okay. Lords had a marathon, my lords.
Yes.
So, my lords, I need fresh directions from my lords to file that additional document, my lords, because my lords.
Fresh direction? When there is a one direction,
no, my lords, the time expired, my lord. There was some technical glitch carrying a printout. So it says that the matter is.
Item number 101.
Yes.
You for the petitioner.
Yes, appellant.
101 million. The petitioner is allowed 4 weeks time or 2 weeks.
2 weeks, lords. We are ready with that.
To file additional documents.
And written submissions.
And written submissions. Post after 2 weeks.
But,
my lord,
deeply mentioned 102. It's a very, very short matter. It retains position a lot in the coming week.
For the respondent in this matter,
102 is a very short matter. Will it retain its position in the coming week?
And yes, if it is not taken up, it will automatically be repeated.
My lord, I have a small request in 103. Instead of the next week, it could come in the week on 28 or 29 January. Grateful, man.
Thank you. अरे किसी को बुलाया
नहीं आया कहीं